to it again? If we need.
What do you mean?
What do you mean?
The Laserfiche is working,
Okay.
No.
so the links should be working.
Oh, I got it.
All right,
Yeah.
you're all set to
got
begin,
the wrong
James.
one. Thanks.
You're all set, Jake?
All right. I will call to order the Zoning Board of Appeals meeting for Wednesday, July 24th, 2024. To all persons interested in or affected by the action of the Zoning Board of Appeals hereby notified pursuant to Section 11 of Chapter 40A of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held again Wednesday, July 24th, 2024 at the time indicated. The Zoning Board of Appeals public hearing will be held by remote participation methods. Public access to this meeting shall be provided in the following manner. The meeting will be televised live via Xfinity Channel 8 or High Definition Channel 1072. May also be accessed via the Government Access Channel live stream on the Town of Barnstable's website, http://streaming85.townofbarnstable.us/cablecast public site/watch/1 $channel1. Real-time access to the Zoning Board of Appeals meeting is available by utilizing the Zoom link or telephone number and meeting ID. Public comment can be addressed to the Zoning Board of Appeals by utilizing that Zoom link or telephone number. The Zoom link is https://townofbarnstable-us.zoom.us/816-929-16753 or by calling 888-475-4499 and entering the meeting ID 816-9291-6753. Applicants, representatives, individuals required or entitled to appear before the Zoning Board of Appeals may appear remotely, may participate through accessing the link or telephone number provided above. Documentary exhibits and or visual presentations should be submitted in advance of the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling 508-862-4682 or emailing anna.brigham@town.barnstable.ma.us. I will call the meeting to order with an introduction of board members. Herb Bodensee.
Present.
Paul Pinard.
Present.
Mark Hanson.
Present.
Aaron Webb.
Present.
Larry Hurwitz.
Present.
Manny Alves is absent. And I am Jacob Dewey. Notice recording this meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 38, Section 20. I must inquire whether anyone is recording this meeting. If so, please make their presence known. Seeing none, we will move to minutes. We have minutes from June 12th, 2024. Does anyone have any comments or questions or want to make a motion to approve the minutes?
I'll move to approve.
All right.
Second.
Do I have a second?
Second, Mark.
Second.
Roll call vote. Herb Bodensee.
In favor.
Paul Pinard.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
Larry Hurwitz. And I am also in favor. So the minutes are approved. All right, moving to our first order of old business, appeal number 2023-042. Patricia Baker and David D. Moir as applicants are appealing the issuance of a building permit, BLDR 23-780, issued on November 1st, 2023. The E.J. Jacksheimer for the construction of a 3,100 square foot, 3-bedroom home for Janet Holian, trustee of the Holian Family Realty Trust. Subject property is located at 240 Windswept Way, Oxford, Massachusetts, and 250 Windswept Way, Oxford, Massachusetts, as shown in Assessor's Map 051 as parcel 012-001 and 012-000, respectively. It is located in the Residence F1, RF1, and Residence Resource Protection Overlay District, RPOD. This is continued from January 24, 2024, February 28, 2024, March 27, 2024, May 22nd, 2024. We do have members assigned, myself, Herb Bodenseek, Aaron Webb, Larry Hurwitz, and Manny Alves. Manny is absent, and I believe you confirmed that Mark was at all these meetings. Is that right?
Yes.
Okay. So, Mark, if you're comfortable sitting on this, we'd have you step in.
Yep, that's fine.
Let's see. Who do we have here? Is Attorney Ford or no?
It's Attorney Timon, Mr. Chairman, for the petitions. Good evening. Thank you for your time, Mr. Chair and members of the board. As the chair just indicated, this matter has been continued a number of times. This is our first substantive hearing session on what is an appeal of a building permit by my clients, David Moir and Patty Baker. Mr. Moir lives at 220 Windswept Way. Ms. Baker lives at 43 Sunset Point. They're the direct abutters to the locus here, which has been identified by the owner as 240 Windswept Way. Our appeal, as we'll elaborate on this evening, is based fundamentally on our position that this is not a buildable lot under Barnstable zoning law and the subdivision regulations, as well as under Massachusetts law. With that, Mr. Chairman, if I might, one of my two clients, Mr. Moir, would like to make some opening remarks, and then he would turn it back to me, and I would conclude the presentation on our side, if that's acceptable.
Yep, that's fine.
Thank you, Mr. Moir.
Hi there. My name's good evening, ZBA members. Sorry. Keep that on. Make this a setup. Okay. My name's David Dangler Moir, M-O-I-R. I want to thank you for agreeing to hear our appeal regarding the development of 250 Windswept Way. Please know that I speak on behalf of 6 generations of the Frost, Dangler, Moir, and Fernandez families who have cherished our family summer home we call Sandy House, located on the rise of the land of Oyster Harbors overlooking Kituit Bay, accessed by Windswept Way. Please know that we have owned this property since 1929, when my grandmother, Margaret Frost Dangler, prevailed over my grandfather and namesake David Edward Dangler to follow her father, Charles Sumner Frost's advice that they purchase this exquisite property on the Olmsted Brothers designed summer estate community of Oyster Harbors. Ours was the first summer estate home built on the island in 1914. We have owned it now for almost 100 years, and I can say that we are certainly the family which has owned an Oyster Harbors property for the longest time. All the members of our family and our friend and neighbor Patty Baker, whose late husband was Alan McDonough, who bought the Kearney property, which is what we know the Holian property as, are extremely troubled by Janet Holian's efforts to subdivide this property in order to develop an additional luxury residence. We all know that her development is seriously overburdening the property in Windswept Way. We all believe that the property is not large enough to be subdivided, considering all the wetland on and by the property, and based on the facts of both Windswept Way and Sunset Point crossing the property, cutting off the area available for a buildable, or cutting off areas available for a buildable lot. We all know that Windswept Way crossing the Holian property is our access way and is used by trucks and other traffic coming to the Holian property from the north. But it is far too narrow to carry all the traffic on it because it has been built only to a 1930 standard of adequacy, despite the engineering allowing it the adequate area to have it properly built to a width of 18 or 20 feet. This section of Windswept Way is only 4 feet or so above sea level. All the adjoining wetlands are even less. It's within the FEMA flood zone that arcs to Kituit Bay. I know from our family experience with Hurricane Bob that this area floods during hurricanes. Further development of septic loads will seriously degrade the common resources of Kituit Bay and the inland wetlands of Oyster Harbors. Also, during all the development of her expanded house, her new carriage house, her pool house, her improved existing carriage house, and other improvements, a shockingly large number of trees have been removed, which has created a tunnel effect, which has damaged many trees, especially on our neighbor Patty Baker's property. I'm speaking for her on that point. We are troubled by we are deeply troubled by the serious problems of the Holians plans as she has filed, as you have laid out. To analyze and to present to you what I see as patently problematic, I would like you to know that I'm going to try to channel the wisdom of my great-grandfather, Charles Sumner Frost, who was an architect born in Maine, trained in Boston, based in Chicago, who was known for his work designing many buildings in Chicago and working with many residences. He was well acquainted with the work of Olmsted Brothers Landscape Architects. He actually owned a property in Northeast Harbor, Maine, in their area, the Acadia National Park. And I believe he recommended that his daughter, my beloved grandmother, Margaret Frost, purchase the property that was originally built by the Starro family on this Olmsted Brothers designed Oyster Harbors as a summer retreat. If you go to Wikipedia, you'll see that I look exactly like him. So I just want you to know there's a sense of I'm representing the family and trying to protect what we believe is ours. We know that the most important contribution of the Olmsted Brothers to the Oyster Harbors community was the common road system they laid out and had registered on January 10th, 1933 in the Massachusetts Land Court within Land Court Case 15354. To pause a second, Ben, you and I talked about that if you could be the webmaster.
Yes, and if I could request access to the screen share, we do have some things we'd like to put up for the board, if we may.
Yes, 1 second.
Thank you.
All right, you're all set.
Got it. Thanks very much.
Okay. Can you see it? I don't see it.
It's on its
good.
way. It's on its way.
Okie doke. Okay, I'm just a second. I need to. Can I do this? Okay. This is fine. I'm reading off my notes, so as long as I see what is on there. Okay, great. Please note the Oyster Harbors Club overlooking Tim's Cove. Please note the way that's now known as Windswept Way that comes off what is known as what is now named Grand Island Drive, but on this is called. Can you make that a little bit smaller? Yeah, yes. There we go. That's right. Perfect. What's shown there is Oyster Way West is actually now known as Grand Island Drive. So notice that Windswept Way starts up by Tim's Cove Road and arches around. Note how the note how the Oyster Harbors Clubhouse overlooks. The way named Windswept Way comes off what is known as Grand Island Drive. It serves the original row of prime estates overlooking Catuit Bay, including at the place there where it makes the corner, the Dangler and Kearney properties. Note that the largest two properties on the island that are registered in the land court, the Kenneth Boyd property and the Frederick Tabor property, there we go, perfect, are on this stretch. I would also like to bring your attention to the fact that it's very difficult to read, but there's this gobbledygook that actually is Winfield. Right there at the bottom of the Kenneth Boyd property was a hunting lodge that goes back into the 19th century. And what we know of as Windswept Way came from the top, was going around the whole area. So Windswept Way was built in the sometime during the 19th century. Okay, let me go back then. So what's so important to know is that the Olmsted brothers came in to help with the layout of the roads in the 1920s and addressed exactly what was going on in this area according to their 1933 Land Court Plan 15354. So if you can now please, I'm sorry, let me continue. Could you back out a bit, please, so you see the whole thing? A little bit more, okay. There, so you see how Windswept Way comes off of Grand Island Drive, goes to the west, goes south, and then loops back to the east and connects back up to Grand Island Drive, here shown as Oyster Way West. So it's very important to see that Windswept Way is one of the original, what they might call ancient private ways that was built on Oyster Harbor's Island before and during the Oyster Harbor's development by the Olmsted brothers. Now, if we could zoom in, please, to page sheets 5 and 6, and we'll see exactly what the Olmsted brothers laid out as the road system for this area. Okay, could you, whoops, come on, stop that. Could you go to the very bottom of this, please? Okay, great, stop, perfect. So where it says Richard Winfield Way, that way was expressly designed so that it would be 40 feet wide. Richard Winfield was actually the fire chief for Mount Vernon, New York. So he knew that lands that had a proper fire access would work better. So that's what Windswept Way, what Winfield Way is. Then you get to the Kearney property. Perhaps it's easier on sheet 6 to see what's going on. Okay, great. And you'll see that Windswept Way is now changed a little bit by the Olmsted brothers from being a way built at the edge of the swamp to being a straight and clear way 20 feet wide. As it says, it's a way per the stipulation filed June 26, 1933. And then if you back out a little bit, you can see where Windswept Way goes. It goes off the property. And it goes back over. While you're there, actually stop on this point just a minute. The Frederick Tabor property is the other rather large estate that's now actually owned by the chairman of the Oyster Harbor's Owners Association that had a very gracious house that was then, that whole property was put into the land court. In order to access Windswept Way at that point, there was a common driveway built that went from the Tabor property, crossing the de Havilland Platte property, going through the edge of the side of the Kearney property and going back up to Windswept Way that later became known as Sunset Point. Okay, the Frederick Tabor property.
We're getting a little far off in history here. Can we just sort of focus on the matter before us and how this is relevant to it?
Yes.
Or just bring it a little tighter?
Sure.
Mr. Moir, could you just turn to the deed provisions, because we are about 11 minutes into your presentation,
okay,
and then I'll take over. Just if you could note the deed provisions that you were going to discuss, please.
Okay. So anyways, my point is simply to say that the deed directly comports to the engineering shown on those plans. I won't go through it, but it's very clear in the section of the deed dealing with the boundaries that the first boundary explicitly references where that Windswept Way crosses that boundary at the northeastern top, and then the fourth place on the deed. Do you want to put this up on the screen?
Well, I'll cover it in my presentation. I'll cover it in my part. Okay.
So anyways, it's clear on the deed, the exact references to the Olmsted plan that's recorded, both in the land court plan and also because it's an older property, it's recorded on a registry deed, but the two are directly the same. Okay. I would now like to turn to the lower section of the deed, which gets into the easement analysis.
Mr.
Again, should I
Mr. Moir,
just speak to
no, I'll cover that.
Okay, okay, so you
Why don't I-
can cover that. Okay, so the basic point that I was going to, Ben, would you like me to make my points, or do you want to pick up?
No, why don't I pick it up? I think the historical context was good, so I'll pick it up from here.
Okay. Okay, great. So
thank you very much.
You can pick it up from there. Okay, thank you.
Great. Thank you. No, I appreciate your attention.
If there are any, before I sign off, if anyone wants me to clarify anything, any comments? Okay, fine. Great. Thank you.
Thank you. Great. Thank you for your attention to that historical context, members of the board. So just by way of the procedural history, very, very briefly, that has brought us here, as the board may know, there was a building permit issued for a single family home for this this lot that is depicted on an A&R plan issued in November. We appealed that within the 30-day period. Subsequent to that, the building permit was suspended. I won't get into all of the back and forth why that happened, although it was based on an issue that we had raised in our original appeal. And then very recently, the planning board endorsed a revised A&R plan, and the building department unsuspended the building permit, which makes this now, again, ripe for this board. As the board is aware, based on, I'm sure handling many different building permit appeals and land use challenges that relate to endorsed A&R plans, an endorsed A&R plan, such as the one here, does not confer any representation of zoning compliance. And that's, as you know, noted on every A&R plan, including this one. And I think my brother, Attorney Ford, who will speak, has made that point as well. The zoning compliance issues are for this board, and the three primary zoning issues that I'd like to briefly discuss in the rest of our presentation this evening are the insufficient lot area for this parcel A under the A&R plan, the insufficient frontage, and the fact that if lot A were allowed to be a buildable lot, it would render lot B less conforming with zoning, which under state law, as the board I'm sure knows, is not permissible. We've laid out many of these concepts in our submissions, but I'd like to start with lot area. And my client, Mr. Moir, made reference to a deed. I'm just going to pull that up quickly. So this is the deed showing up on everyone's screen?
Yes, you can see it, but make it a little bit smaller, please.
Thank you. So this is the Holian deed for 250 Windswept Way, the property that has been divided under an A&R plan. And the key thing to reference here is, I won't get into the easement issue, but here at the bottom of the second page, it describes the land that is not part of this lot. And specifically, it says, no fee interest in any of the private ways on Oyster Harbors, now owned by Oyster Harbors Incorporated, connecting the premises herein, conveyed with the town road leading to Osterville or otherwise, and no fee interest in the 30-foot way shown on the plan, dated April 4th, 1968, and recorded with this book and page number, etc., to the east of the easterly boundary line of the premises are herein or hereby conveyed. If you look at the plans in question, and my client began to give some historical context to this, the land on Windswept Way, which Ms. Holian purports to include in her lot, is actually not her property. It's not land that she can include in her lot, and it's inconsistent with the deed, which, as the board knows, controls in matters of a property's boundaries. We submitted with a prior submission Legacy Engineering's annotation of the A&R plan. So this is the A&R plan that was prepared in May of this year. It's not the one that was actually approved by the planning board. That's a June 26th plan, which I'll put up. But this particular plan was what we had at the time when we were making this point at the planning board, which happens to be quite relevant to this board as well. And the boundary lines have not changed. The only changes between these plans pertain to how frontage is being claimed. But what this shows is the amount of land that so-called parcel A is claiming in order to, as you can see here, achieve 87,139 countable square feet. That's 19 square feet, I believe, over the 2-acre minimum. So it just barely goes over as far as countable square footage, because they've, as you see here, deducted wetlands properly. But there is about 9,400 square feet that encompasses both the windswept way right-of-way itself, which is in brown, and land on the other side of windswept way, which is in blue. That land is not properly countable towards lot area for 2 reasons. One, because it's actually, according to the deed, not part of the land. And 2, and this gets to language in the subdivision regulations defining what a lot is. So a lot under the subdivision regulations, which are applicable to this matter because we're dealing with a lot that is purportedly buildable pursuant to an A&R plan. That's how the lot was purportedly created. The definition says an area of land delineated by lot boundary lines in one ownership and not divided by a public or private way. Now, the zoning bylaws for the town use the terminology of not bisected by a street, and the word street is not defined, but here it is defined more finely, and it pertains to a way. We think that even under the zoning bylaw definition that this qualifies as a street. We don't believe that in order to qualify as a street, it has to be the type of way that would meet the standards of adequacy for frontage, which we're going to talk about. And Attorney Ford, in a prior discussion, sort of made that an either-or type of scenario. It's not. But again, if the language of the subdivision definition for lot is key, not divided by a public or private way. So as we point out and elaborate on in our submissions, and as shown in this annotated plan by Legacy Engineering, Dan Merrick, PE, this area should not be counted. Now I'd like to turn to frontage. And for frontage, let me turn again to the definitions here. So this I'm sure is familiar to the members of the ZBA. So under the definition of a subdivision, under state law, chapter 41, and then under the subdivision regulations here, it defines A, B, and C, what is a sufficient way for frontage. And again, this is in the subdivision regs, yes, but under every case that I'm ever aware of where I've litigated what's a sufficient way for frontage, it's some variation of these definitions that govern whether or not there's sufficient frontage to constitute a buildable lot. And there are 3 categories here. One is a public way. Well, neither Sunset Point nor Windswept Way are public ways. We know that. B is a way shown on a plan previously approved and endorsed under the subdivision control law, which has been fully constructed in compliance with the subdivision rules and regulations in effect at that time. Also inapplicable, and I believe Attorney Ford concedes that A and B are not applicable. The debate is, as it often is in these matters, is over C. And what Barnstable has done is it's created a 3rd category that is actually quite a bit more stringent than state law, which is allowable, as you know, under zoning bylaws. And it's a way in existence when the subdivision control became effective, which meets the standard of adequate access established by section 801.12b of these rules and regulations. A lot of this is laid out in our submission, But this is really the key here as to why, in the most straightforward way of demonstrating why there is insufficient frontage on either Windswept Way or Sunset Point. Take your pick for whichever frontage the Ms. Holian is trying to achieve. So as you can see here, it's 1 to 4 dwelling units and 5 to 10 dwelling units. Those are the potentially applicable categories to these two ways. And as you see, the minimum right-of-way width is 33 feet, and the minimum surface width for 5 to 10 is 18, and for 1 to 4 is 14. You have to kind of get into the asterisks there. Now, what Mr. Merrickin's annotation on this front shows, and let me just pull this up for the board, and we'll add this to the hearing record as well. As it says here, this is a markup of a record plan by Legacy Engineering LLC. Mr. Merrickin had a conflict tonight, so he couldn't be here himself, but he's prepared this plan, and he is a PE. So again, this is the actual June 26, 2024 A&R plan that was just recently endorsed by the planning board. Again, not holding any weight in terms of zoning compliance, as it says here, no determination as to compliance with the zoning ordinance, etc. But the key thing that I'd like to show here is that is really two things that speak to frontage. So one is, and let me just shrink this a bit. Okay, so we have parcel A and parcel B. Parcel A is the locus that we're talking about, the one on which Ms. Holian wishes to build a new single-family house. Parcel B is improved already with a single-family house and a series of outbuildings, and these two parcels together used to be 250 Windswept Way. And so we need to show frontage on both of these new lots, and Ms. Holian's position is that they have frontage on Sunset Point. As you can see, there is no access from this common driveway, which does service parcel B and the homes there, and will service parcel A and the home there if it's allowed to be built. There's no access from those parcels to Sunset Point. Now, the debate that has arisen before is, does there need to be physical access on the ground, or does there just need to be a plan for access, or physical potential access? As we point out in our submissions, we think the case law is clear that there needs to be actual access on the ground. But in any event, access to Sunset Point is not even proposed. So there's nothing on this plan, nothing that I'm aware of that's been submitted by Ms. Holian that even proposes that there be access, a connection to their claimed frontage, Sunset Point. With respect to standards of adequacy, the width, which is the second reason why these rights of way are insufficient. As this aerial annotation shows by Mr. Merrickin, Sunset Point has 30 feet of right-of-way, and if I can show you, and I'll pull it up on the plan itself, this is the same plan as endorsed, and you can see that, sorry about that, you can see that Sunset Point right here states 30 feet of right-of-way. Again, the required width for a road, a way sufficient for frontage is 33, not 30, 33. So Sunset Point fails that particular standard. And as shown on Mr. Merrickin's aerial, the surface width is somewhere around 12 to 13 feet, also insufficient under either of the categories for the number of dwelling units. Sunset Point cannot be a way sufficient for frontage because it fails at least those two standards of adequacy. Ms. Holian has also claimed, although they varied in this position as to the extent to which Windswept Way provides a right of way, its travel surface width is 12 feet. It needs to be 18. So even if one were to accept that 20 feet of frontage, which is the frontage requirement for this zoning district, is available here, it's on Windswept Way, it's not, because not as legal frontage to create a building lot, because it doesn't meet the standards of adequacy. The final point, I appreciate very much the board's patience with the length of this presentation, but my final point is that the case law is very, very clear, and I could cite a number of cases on the concept of infectious invalidity, the notion that you can't create a new buildable lot if it's going to render an existing lot non-conforming or more non-conforming. And, I have here in this summary a number of cases that say that, including a 2004 land court case called Norton v. Donahue, which found infectious invalidity when an A&R plan made an already developed lot non-conforming as to frontage. That's what has happened here, in that parcel B, an existing improved lot, has now been carved off, needs to stand on its own feet. This is also language from the case law, and have its own frontage. And it's indisputable that parcel B, under this A&R plan, could only possibly have frontage on this swatch of Sunset Point. And as I've demonstrated, Sunset Point, without question, does not meet the standards of adequacy that your Barnstable law requires. It cannot be a way sufficient for frontage. And because parcel B cannot be a way sufficient for frontage, it is rendered non-conforming with zoning by virtue of the creation of parcel A. That is contrary to case law, and in and of itself prevents the issuance of a lawful building permit. So again, I'm grateful for the time that you have afforded us this evening, and I'm happy to answer any questions that the board has about our appeal.
Thank you, Attorney Simon. Does anyone have any questions for the applicant? Or go ahead.
Oh, no, I just hit my microphone.
Okay. Anyone else?
No, just like to hear the rest of it. Yeah.
I'd like to speak at some point, Mr. Chairman. This is Mr. Ford.
Yeah, I guess Attorney Ford, if you want to respond, I don't have any specific questions yet, but so if Attorney Ford, you want to go ahead.
Thank you. So I represent Mrs. Julian in her capacity as trustee of the Julian Realty Trust. By way of background, and I'm not going to go through the background that Mr. Moir did, but I will comment on it just briefly where I think it's material to the issues that are before you. The original A&R plan, when it was signed, had a wetlands line on it, and all of the calculations with respect to the initial lot area and lot shape were made based on the wetlands line that was on that plan. And that was the wetlands line that was on the plan when my client bought it. After that plan was approved, a house was designed, and we applied to the Conservation Commission for an order of conditions to build a house. And of course, Mr. Moore and Ms. Baker were both notified of that. And they appeared and objected at the Conservation Commission. As a result, however, the Conservation Commission hearing, the Conservation Commission wanted an updated wetlands line, and the updated wetlands line changed the wetlands line to be more conservative than the one that was on the original A&R plan. And so that's the reason that we then went back to the planning board to get these two lots withdrawn, because the old configurations, Lot A could not meet the shape factor because the new wetlands line left less upland on that lot than before. Left 2 acres of upland, but not in the shape to meet the shape factor. So we went back to the planning board. Let me step back 1 second, Mr. Chairman. After we got the order of conditions, which was not appealed, objected to it at all the hearings by these two, but was not appealed, we then filed for a building permit. And that's on the old A&R plan. And when the building permit issued, and as you all know, a building permit is an ex parte proceeding. The neighbors don't get notice of it. I advised my client, because they had objected, Mr. Moore and Ms. Baker, at the conservation proceedings, to send them copies of the building permit and advise them that it had issued. And that's how they got notice of the building permit and were able to file an appeal in 30 days. Because my client said, yes, let's get it out to them. Let's get it all on the table. So that's the genesis of how this appeal actually got filed. We sent it to them, certified mail, and then they contacted council and took the appeal. Then we came to the Board of Appeals, then, and I was ahead of myself there. That's when we discovered the lot shape error, and it was an error on the initial plan because it utilized the old wetlands line. You allowed us to appeal after the building commissioner suspended the building permit to go back to the planning board. It's taken us, the land surveyors did redraw the lines. It was the common lot line between the 2 lots that got redrawn so that both lots met the shape factor. We resubmitted the plan to the planning board, and we were continued for another month because planning board didn't have a quorum. And actually, you can't continue an A&R plan, so we actually had to withdraw it and then refile it again. And then the planning board had a quorum and they signed the plan. All of the arguments that you just heard Mr. Tynan make under the subdivision control law with the subdivision regulations, citing all the various sections of the subdivision regulations and citing all those arguments as to frontage, were made to the planning board prior to the planning board's endorsement of the plan. They were made in a submittal, and all of the planning board members indicated that they had received it. At the planning board hearing, chairman took the position that it was not a hearing, it was just an A&R plan. They get signed at a meeting, and therefore he was not going to recognize anybody. Mr. Moore and Ms. Baker were there with counsel. It was an associate from Mr. Tyman's office. And so what the chairman did, he said, look, you've come all the way down here. What I'll do is allow you to speak under public speak. And you can make all your arguments there and the planning board can listen to them. So they did. Both Mr. Moore got to speak, Ms. Baker got to speak, and their counsel got to speak. And all of these issues regarding problems with the subdivision control law and the board's finding that there was frontage on Sunset were aired before the planning board, and the planning board signed the plan finding that under the subdivision control law, Sunset Point provided adequate frontage. What Mr. Tyman hasn't told you is that I provided to the planning board 2 plans of Sunset Point. One back in the 60s, which was signed by the Board of Survey, showing Sunset Point being 30 feet wide coming off of Windswept. And then, ironically, an A&R plan that they had endorsed that created Miss Baker's lot, the lot that she now owns. That's how she got her frontage, off of Sunset Point. And that was endorsed by the planning board as an approval not required plan previously, using Sunset Point as frontage, and was signed by John Rosario back when he was on the planning board. So the planning board made a finding that Sunset Point was a suitable access, had been shown on a prior subdivision plan, albeit an A&R plan, not a full subdivision plan, but an A&R plan. And so there is precedence for that road being used as frontage, and they felt comfortable over it. So that brings us to the next question regarding frontage, and that is, when you have sufficient linear frontage along a road that's been found to be adequate, do you actually have to have your access off of that linear frontage under the zoning ordinance? The answer is no. In some towns you do. Town of Dennis, town of Howard, I can think of a number of towns I practice in, town of Chatham. There is a specific provision in all of those zoning bylaws that says you have to have your access off of what is your legal frontage. There is no such provision in Barnstable. I've discussed it with the building commissioner. I asked him to address it when he lifted the suspension to you. He has, and he agrees when he lifted the suspension that there is no requirement as long as you have legal access off of Sunset, which we do. I filed a memorandum to that effect to show we had legal access with the planning board and with the building commissioner. And you actually can have physical access. It can't be illusory. You got to be able to put a driveway in if you wanted to, which we do. So what are we doing? Miss Julian, who's trying to build a house for her brother on this lot, is going to come down her current driveway off of Windswept. And there'll be two houses off of that. What does that do? That saves another curb cut off of Sunset in this area, which is what we heard from the neighbors they wanted. And it also saves trees, which Mr. Moir is indicating that he's wants to save. My client does too, which is why she doesn't want to build new driveways off of Sunset Point. And the bylaw in Barnstable, the ordinance in Barnstable allows you to do that. And the building commissioner agrees with that. And I put that question to him specifically. Now, as to the question of lot area, Mr. Moore took you through the history of Oyster Harbors. What he didn't tell you was that my client's property is not land court property. His property is not land court property. When the 20-foot right-of-way shown on the plan that's before you was put on the ground, it was put on the ground by way of a stipulation and was noted on the land court plans. Noted, but not shown. Why is it not technically legally shown? And I'm sure Attorney Timon knows this, because it's not land court property. And so the land court did not decree any ways over that particular property. They simply noted it, that it was on the ground. Oyster Harbors does not own and never did own the 20-foot wide right-of-way. My client owns the fee in it. Brian Florence, when I went to him, I analyzed this property. He did not feel that it was a street. He did not feel that it rose to the level of frontage within the meaning of the zoning ordinance. He did feel that Sunset rose to the level of frontage because it had been shown on prior plans signed by first the Board of Survey and then the planning board for an A&R plan. And Sunset was 30 feet wide. So he reasoned the right-of-way, which is not land court property, was simply an easement in which people have rights of way by stipulation. Mr. Moore has a right of way. People beyond Mr. Moore can use that road. It is an easement. My client owns it, and it can be used as part of a lot area. And that's the opinion of the building commissioner, and I believe he is correct in that. Now, the issue of the deed, while this is probably not an issue that's before you, Mr. Chairman, since you're not a land court, but Mr. Timon has, Attorney Timon has decided to put it before you anyway, but I don't think you have any jurisdiction over how to interpret a deed. But I want to simply respond for the record. The paragraph that they referred to, that no fee interest was granted to my client, was on ways owned by Oyster Harbors. Windswept Way is owned by Oyster Harbors, where it's actually laid out to be 40 feet on either side of my client's property. The little connector road in between that Mr. Moore likes to call Windswept Way, but has never been shown on any plan as Windswept Way, is in fact owned by my client. That language in the deed does not prevent the right-of-way, the fee in the right-of-way going to my client. And we're very comfortable in that, in terms of that interpretation. Now, that paragraph goes on and says, we've got no fee in Sunset. And so that's why we created Lot C and D. Because Sunset Way is actually, Sunset Point has actually been used as frontage, including by one of the objectors, Patty Baker, for her lot, for several lots in that area. And so we carved those off. Why? Because, as Brian Florence worked with me on this, no portion of our lot is to be bisected by a street. And he reasoned that Sunset is a street because frontage can be taken from it. But the right-of-way, the dotted line right-of-way that runs between the two sections of Windswept that are 40 feet wide is not a street. And therefore, those reasons, we feel the lot has sufficient area, has sufficient frontage, that the lot shape factor has been corrected, and the building inspector's lifting of the suspension of the building permit is correct. And we would ask you to uphold the decision of the building inspector. Thank you for your time.
Thank you, Attorney Ford. Before we open public comment, does anyone have any questions for the applicant or Attorney Ford?
Could I ask one question very quickly?
Go ahead.
For Attorney Ford. So parcel A currently, you were mentioning that is a family member that wants to build there, and they're going to use that current driveway. In the event that that was sold, would they have the ability to come off Sunset on parcel D and create a driveway into parcel B?
Nothing would prevent a driveway coming off of Sunset in the future.
To parcel B?
Parcel B.
Okay,
Or
so it could have its own driveway off of Sunset. It's just
absolutely, which is why, and if I may, Mr. Chairman, with your permission, I don't believe, I'm very familiar with the doctrine of infectious invalidity, and it's not in play here. And it's not in play for the same reasons that I gave you on the new lot. Parcel B has frontage on Sunset, but it's not required to build that frontage as long as it's the sufficient linear frontage, which in this district is only 20 feet. That's the only frontage you need in this district. And we have actual physical right to physical access. And that's why this lot is not more non-conforming. And that's why infectious invalidity and the doctrine of it doesn't apply here to parcel B.
That was my only question.
Attorney Ford, so just going through the notice of suspension. So the building commissioner, unfortunately, he's not here tonight, but his reason for the notice of suspension was just because of the lot factor. He didn't have any other zoning.
That's correct. That's correct. But then, as you might have seen in his most recent submittal lifting the suspension, I advised him that the appellants, through their counsel, Mr. Tynan, had raised the question of whether or not you actually had to have your physical access off of your linear frontage. And I posed it to him. And when he lifted the suspension, he opined on that and said he agreed that you did not have to, so that we could have this house go forward simply off a driveway, saving a lot of curb cuts in this area. I also raised the issue of whether the right-of-way that stretches between the two 40-foot layouts of Windswept, whether that was a street. And if it was a street, then the zoning ordinance, which is what is at play here, not the subdivision regulations, the zoning ordinance says that a lot can't be bisected by a street. And he said, in his opinion, it's an easement. It's not a street. It's never been shown on a subdivision plan. It's never been used on an A&R plan, board of survey plan. And it's actually doesn't get the benefit of a way shown on a land court plan prior to the adoption of subdivision control. And some of those ways actually can be frontage. But it hasn't been because this is not land court property. My client's property is not registered land, and neither are the properties of the two appellants.
Okay. I didn't see there. I saw your correspondence to the building commissioner, but did he respond again more recently than the initial suspension?
Yes, he did. I forwarded his email to Anna and attached my letter to him to show you that it was in response to my letter. And in that, he goes through those series of questions. Anna forwarded it to all of you when I got it. I didn't get it till late Friday, so I sent it to her on Monday. You probably is in your email from Monday, Mr. Chair.
And is that in the Laserfish?
Mr. Chair, I believe it's submission from Attorney Ford #1 and submission from Attorney Ford #2 at the bottom of the Laserfish list. I can share those.
Okay, not the correspondence.
No, it's not in course. It's in the list of documents at the very bottom.
No, that's not it. Does anyone else see it in there? I don't see.
I don't see it either.
I don't see anything from the building commissioner other than the suspension. I see Attorney Ford's correspondence to the building commissioner with attachments, but I do not see a response from the building commissioner.
Yeah, when I forwarded to Anna, what I did was forward his email, and my letter was attached. So it's not an attachment, it's actually an email from the building commissioner where he goes through all of this.
Attorney Ford, I just have a quick question regarding Windswept Way and the dotted line there. Are you saying, and again, don't take this wrong way, but the Windswept Way is 40 feet prior to reaching the northern side, I guess it would be, of parcel A, then becomes an easement to 30 feet that is owned
No,
by...
it's only a 20-foot right of way at that point.
And then,
It goes from
and then
40 to
opens
20,
back...
and then it goes
20,
back
excuse
to
me,
40.
yep. And then it goes back to 40 as it approaches the westerly side.
You got it.
If I'm looking at the map correctly, your
You're correct.
diagram. Yep.
Yes. Yep.
Okay, that's my only question. Thanks.
Mr. Chairman, Anna, is there some way you could put that response to the building commissioner on the screen? That email, so the chair could see it and others?
So I have
So, Anna, just so you know, you forwarded an email to us. I believe it came on Monday. That did include from Jeff Carter, I believe, his email and the points.
I think it's
And Brian Florence. Yep.
So, Attorney Ford, this is
No, that's the letter to him.
to him. So isn't it attached to this?
It's not attached. It was actually an email that I just forwarded to you with my letter.
Anna, if you give me a minute, I can upload it to Laserfish right now. Just give me 1 minute.
Okay, that'd be great, Jenna. Thank you.
I think it's important that the board see his responses.
Mr. Chair, while we're waiting for that, could I make two very quick rebuttal points? Or would you prefer to wait? Thank you. So I'd simply like to say that, and I disagree with Mr. Florence if his position is that there need not be at least a plan of access to the claimed frontage. And in our letter that we submitted, I cite to the Ball case that says and this is state law. This is not with respect to any particular idiosyncrasies within zoning bylaws. Firmly establishing that a frontage road must at minimum, quote, provide present tense, acceptable physical access to the lot in question. And Mr. Ford has said this evening that there is no plan. In fact, there's been a decision apparently not to create a connection to the claimed frontage road, which is Sunset Point. And then my second point is there's no way to reconcile the agreed upon, stated on the plan itself, 30-foot width of Sunset Point as a right-of-way with the requirement that it be 33 feet. And I don't believe that Mr. Ford is denying that there are 3 ways to be a way sufficient for frontage under Massachusetts law, that those definitions do in this case and in almost all cases arise from the subdivision rules. So this part of the subdivision rules is directly relevant because it governs what is a way sufficient for frontage. And the only category that could apply here would be the one that says that way must comply with the standards of adequacy, which include, again, 33 feet width of right-of-way and 18 feet width of surface roadway. And neither of the ways that we're talking about have that. It's in black and white. So those are irreconcilable. And I don't think that Attorney Ford can reconcile those numbers.
You don't have to reconcile those numbers, if I may respond, Mr. Chairman. You can, which the planning board did. They simply fell down under number C, a road that existed prior to the adoption of subdivision control, and they found that Sunset Point went back farther than the adoption of subdivision control. So we didn't even have to get to B.
No. C has 2 parts. One is what you just mentioned. The other is that and meets the standards of adequate access set forth in that other section. So that's the other part of the definition.
Adequate access, the board has complete discretion over, which is obviously evident by the fact they continue to sign these plans. So I know this isn't an appeal of the planning board action. I know you're trying to make it one, but it's not. This is the zoning board.
Right.
So we're looking at Mr. Florence's decision.
Yeah, I was going to make that point too, that some of these things we're referencing are planning board regulations, not zoning. What's before us is an appeal of a zoning determination. I always have a hard time here, going against a decision the building commissioner has made when he's not here, and I don't think he's here to sort of speak to his conclusion on this. But we still have to go to public comment. Are there any board members before we go to public comment with any questions or things they wanted to add?
Well, I just wanted to add that I did find the email that had been referenced, and it was sent.
Yeah.
I myself was, I read the attachment, which has correspondence from Attorney Ford, Building Commissioner Florence, and Jim Kupfer. That's just the correspondence. It's called POM 202-407-19-0001 PDF. But in the email from Anna itself is the text from Attorney Ford and from Building Commissioner Florence. And that email is dated I have everything else but that. Monday. So just to clarify that was a good read and really clarifies quite a bit of what we're talking about right here. So I hope that helped.
I did just add that to Laserfiche. So if you refresh Laserfiche, it should be available now. It's entitled Email from Commissioner Florence.
I would commend it to you. It's not very long.
All right, let's open public comment. Is there anyone here to speak to this item?
If I may, I just have,
Yep.
This is Brooke Baker. I just have one question for Attorney Ford, if that's okay.
Can you just say your address, full name and address for the record, please?
Brooke Baker, 483 Sunset Point. I am Patty Baker's daughter.
Yep, go ahead. Thank you.
So, Attorney Ford, so I just had a question. You had stated that the street that goes by Mr. Moir's property had never been considered Windswept Way. Is that correct?
What I said was that Windswept Way has been shown on plans that have been laid out, used as frontage by the planning board on two 40-foot sections of Windswept Way. That the right-of-way that connects those two, which goes to Mr. Moyer's property, has never been shown on any plan called Windswept Way.
Okay, so apologies. I'm not very savvy in what this planning looks like, but I know that there's been for years and years since we've lived in that house since 99, that Oyster Harbor's actually had to add like a South Windswept Way sign to our turning point because Windswept Way goes off of Grand Island Drive long before you get to our street near Sunset Point. It comes down and around and dips down past Miss Julian's property. So I just wanted to clarify because I wasn't quite sure what that comment meant. And of course, like, I don't want to cause any problem here, so I will end my comments now. But I'm curious about the wetlands being adjusted. As somebody, you know, I walk past Sunset Point a couple times a year. I'm down there in the summer to visit my mom. And there's water that's a couple feet from Sunset Point actual road on the right as you're leaving, going towards Windswept Way. So I just want to know how those lines were adjusted.
If you want me to respond, Mr. Chairman, I will.
I mean, none of us are engineers here, you know, of how they determined those lines, but I believe it got more wet than it was originally.
Yeah,
correct?
but not in that, it was not redone in that area because no construction was taking place in that area. It was it was in the area of the 20-foot right-of-way that runs between the two Windswept Way 40-foot layouts. That was the area of wetlands that had to get redone.
Thank you for that clarification. I appreciate it.
Is there anyone else here from the public who would like to speak to this? Page one. Anyone?
Can I speak to the to a point that has not been, that is a clear, important point of clarification?
Yep, it's public comment. Yep, just try to keep it to 3 minutes.
Ben, could you pull up the plan that we were going to talk about, but then it got pulled up, where we see exactly how the land court, that's it. And do you see that it says way 20-foot wide? What we're talking about is where Windswept Way crosses the Holy Inn property, the way that is regularly plowed along with the rest of Windswept Way, which is regularly transited by people on Oyster Harbor's Island, that's treated exactly the same way as the right of access of a way of access. It says way 20 feet wide private. Then it says way 40 feet wide private. Then notice what it says, what crosses the Kearney property. Ben, could you be so kind as to broaden it so we can see it a bit more clearly? It says explicitly right of way, which is to say that it would be overburdening a common driveway for a shared driveway for Kearney to use right of way rather than the pre-existing way. So the point is that this is not properly shown on the LURA plan, that the land court designation for Windswept Way is a way 20 feet wide, private, that is at either end goes into ways that happen to be 40 feet wide. Why it's a difference of 20 rather than 40, who knows? The point is that they are both ways. They are both in active use. They are windswept way. Also, to make a point to what Brooke said, I'd like to clarify that north of my property, where it says, I was beginning to talk about where it says Winfield Way, that is a 40-foot wide way, easement area. At some point, the Blakely family that lived there decided they wanted to restrict the width of the way as laid out and installed stone boundaries, stone pedestals 14 feet wide to make it look to all as if it was no longer a full windswept way access way. They felt since it crossed their land, they could develop it and restrict it any way that they wanted. My family is a very gentle and kind family. We were not into rocking boat, but it was clear that there have been efforts by the people across which the way follows to be bad neighbors and make it difficult for the property at 220 Windswept Way to access it. We have now found our only way to get emergency trucks to our way is coming as best we can through the 20-foot wide way. It is now very difficult to go through where, by the way, as should be made extremely clear, when we're talking about adequacy of way, we're talking about bituminous concrete at least 18 feet wide. It is not bituminous concrete 18 feet wide through that section. Instead, it is pea stone. It makes it hard. Thus, whatever happens with this hearing, the Moir, Dangler, Fernandez family are going to be making efforts to bring Windswept Way clearly up to fire access standards so that we can have the proper fire protection that is afforded everywhere else. So I think it's extremely important for Mike Ford to be honest and respectful of his duties to the land court, not to represent what the land court is looking at. The land court simply oversees how these plans and these deeds have been drawn, what the data on the ground is. And since 1933, it's clear that what is on the ground and recorded in land court, Windswept Way is a land court way. The properties coming off of it are not fully in land court, but that does not mean that the land court is reviewing that the rights and obligations, which include that wholly and not use that way as in fee simple. No, it is the through road. That is what's recorded. That is what is true. And to say it's not true is, and if we need to go to land court, they'll be happy to look at it and see exactly what's going on here. So I just hope everyone would look clearly at that plan and see what is clearly of record. Thank you.
Mr. Chairman, could I respond to that? It's Mike Ford.
Yeah, sure. Go ahead.
Would that plan go back up?
Sure.
So a close examination of this plan will show you it's not a land court plan. It's a plan filed in the recorded side of the registry of deeds. It doesn't have anything to do with the land court. It is a plan signed by the Board of Survey of the town of Barnstable, recognizing Sunset Point coming off of Windswept Way. And if you pull the plan up a little farther, you'll see that it goes down. That's what was happening with this Board of Survey. They were extending it down so that lots farther down there could get frontage. And then later
Absolutely not. It is formalizing the Pitcairn Drive.
Can I finish?
Hey, no, there needs to be some order. There needs to be some order, please.
Can I finish, Mr. Chairman? So
Yep, go ahead.
this is a plan of a right-of-way at Oyster Harbors, as it's labeled, and the right-of-way is Sunset Point, and it's not a land court plan. and it doesn't purport to do anything with respect to the 20-foot way that Mr. Moore is talking about. Now, that said, my client fully recognizes that the Moore family has a right to use all of the 20-foot wide right-of-way for all purposes to get to their lot. No one is going to try and prevent them from improving that to the extent they need it for fire access or anything else. I just want to state that on the record. That's not what we're about here. Thank you.
Thank you. All right. I think we did not receive anything in the mail regarding this or any emails, correct? Anna and Jenna? I don't think so.
Correct.
If there's no one else here to speak to it, I'm inclined to close public comment unless the board member has thoughts on that or doesn't want to close it. So want to make a motion to close public comment?
Motion to close public comment.
So moved.
And a second. Roll call vote in closing public comment. Herb Bodenseek,
I'm in favor.
Paul Pinard. Paul, you still there?
Yeah, but I'm not involved.
Oh, sorry. Mark Hanson,
I'm in favor.
Aaron Webb,
I'm in favor.
and I'm also in favor. So I close the public comment, brings it back to the board for deliberation, or we can make findings. The public hearing is still open, so we can take more testimony, but we can close public hearing as well. Does anyone have any thoughts on this? I'm not sure where I'm going with it.
Well, I think at least if we can acknowledge for anybody that's listening maybe and isn't seeing, can't visually see this, that, the question about the 20-foot way, that the building commissioner is determining that it's no different than an easement. That is his determination. And that the frontage is not a requirement in Barnstable. So I think that was the question. Parcel A or B have legal frontage because they're not taking physical access off Sunset Point. Agree with Attorney Ford's conclusion that this is not a requirement in Barnstable. So those were the only questions I really had, because Attorney Ford, without being able to read this from, Building Commissioner Florence, it was a bit hearsay, and I'm not saying that in a way that we need to see that the actual response.
Any other board members have any thoughts, or does someone want to make findings? I mean, we're either upholding the building commissioner's issuance and I guess reinstatement of the building permit, or we're overruling the building commissioner's decision to issue the building permit.
Mr. Chairman, the permit already was reinstated, so it's an active permit before you. He
Correct.
lifted the suspension.
Yeah.
That's all part of that email that unfortunately hasn't been seen.
Mark, do you want to make findings, or?
I'm just thinking. So is this?
You continue this and ask the building commissioner to come to the next meeting and give us his rationale and explanation of how he got to where he got to.
I prefer it only because I think it's sort of a he said, she said here, where I just like some clarity on how we got there, because the road is really the question here, I think, more. And I'd like to know more about why he believes it's an easement or no different than an easement.
Okay. So Attorney Ford, would you be agreeable for us to request the building commissioner come to potentially our next meeting to continue this?
Certainly, I'm agreeable to that if that's the board's pleasure. Yes.
Yes, I am as well, Mr. Chairman. It's unfortunate we just can't bring up that email from him that apparently has now been downloaded, so you could all see that tonight, just so that the comments about hearsay are at least put aside. Apparently it's there if you wanted to look at it.
He's saying that it's determined that the way does not deduct, but he doesn't say why. He doesn't say how he determined that.
Okay.
Aaron, do you have a comment?
I don't, except I feel like his reply to the email is in front of us, and he does state, again, according to the building commissioner, Brian Florence, I have determined that the way does not deduct from area and is no different than an easement. I mean, I don't know what we're gonna gain from hearing him, and coming back here again for another hearing, but I'm not in a position necessarily either to make findings per se, but I am leaning towards upholding the building commissioner's decision at this point.
Could I ask one more question?
Yeah.
I'm not sure if this is for attorney time and just briefly, is the main concern from the petitioner that they won't have access or they think there's going to be some increased access? I mean, it's on the other side of the street. I'm just trying to determine what the true, there's not a view easement here or anything like that. Is there not some sort of, is this the major issue, just that they don't want a building there?
Well, certainly neither Mr. Moir nor Ms. Baker want a building there, but what really, on the issue of frontage and adequacy of the way, I mean, respectfully, they just want the language of the applicable standard to be enforced, which again says meeting the standards of adequate access established by Section 801.12b. And those lay out what the standards are. And I'm hearing from Attorney Ford that maybe building permits have been issued in the past for properties that whose frontage does not meet the standards of adequacy, but that would be in violation of your standard. And so it does pertain to the concern over the inadequacy of these ways. They're already inadequate to service the homes that are there.
Maybe if I could just sort of clarify what I'm saying here.
Yes.
If those roadways met the standards, does your client have an issue with a home being built there? And the reason I'm going here is because the building commissioner has determined that it's no different than an easement. So, we're probably more apt to go in that direction. But is it not wanting this because it's not meeting those factors, or is it just because of the home being built there? Maybe you know what I'm saying?
Yeah, I think.
Would you like me to answer? I mean, our understanding is very
No.
clear.
Public comment is closed.
The zoning board of appeal to uphold
Public
the
comment
level
is
of
closed.
Public comment is closed.
development.
Order.
Sorry.
So to answer the question, it would be an entirely different analysis if these ways were improved to be brought up to the standards of adequacy. But that is not something that has been proposed as part of this application, and I don't believe there's any intent to bring the ways that are being claimed for frontage up to the standards of adequacy.
I'm just trying to determine from their standpoint, from their perception, what their hardship is.
Mm-hmm.
But Mark, we're not looking for that. We're looking.
No, I know. I'm sorry. I'm just trying to determine based on.
Yeah. No, they're concerned about the current inadequacy of these ways and adding an additional burden to that. And then I realize this wasn't, exactly your question, Mr. Hanson, but I do have to, turn again to the related point that's what the legal standard is as well. Standards of adequacy for a road.
And I appreciate your presentation, Attorney Time, and I truly do. Again, what I find to be somewhat concerning here, or maybe out of our purview, is whether or not the easement is part of the parcel, allowing it for lot coverage to be the 2+ acres that's a buildable lot, right? You did argue at the time that was owned by Oyster Harbors and shouldn't be included in the land total of the parcel. So I'm not sure we have the ability here to make that decision other than listening to what the building commissioner has to say about that. And I don't know.
So Aaron, like have the building commissioner. We have a bunch of things on the agenda. So would you like to have the building commissioner come back as well, then to answer some of those points?
I mean, I guess, other than I do, we have an email here where he states those things. So again, if that's the majority decision of the board, I'm fine with it. I can't imagine continuing this to another date, but if that's what we need to do.
And if I may, Commissioner Florence, in his writing, in his email part of the writing, he is responding to what is set forth by the planning board. He doesn't, you're saying that, or someone said that his actual reasoning wasn't stated, but he's responding to the planning board. I don't think it's necessary to call him back. I think we can make a decision without his presence.
I'm fine with that.
Does someone want to make findings?
I have a procedural question, Mr. Chairman. We have a 3-prong test to apply, I believe. To which party do we apply?
No, we don't. No, we don't.
No, we don't?
A variance.
Okay.
This to uphold the building commissioners. They do need 4 votes, I believe, to overturn the building commissioners. They would need 4 affirmative votes.
Yeah, that was the second part of my question.
So if someone wants to make findings, we can make findings, or if someone wants to make a motion to continue and request the building commissioner come to the next meeting, I think one or the other should happen here. Anyone?
I'm looking, hold on.
I think I can do it. So we are.
I mean, there's not a lot to do. You just have to do it. Do it. And we also need to close the public hearing.
Okay, let's close. I'll make findings if you want to close it.
I'll make a motion to close public hearing.
Okay, so I'll second the closing of the public hearing. Roll call vote on closing the public hearing. Herb Bodenseek.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
And I'm also in favor. So no more testimony can be taken. Mark, go. You want to make findings? Sorry.
Yes. With regard to appeal number 2023-042, Baker and Moir, appeal of building commissioner's issuance of a building permit. Patricia Baker and David D. Moir as appellants are appealing the issuance of building permit BLDR 23-780 issued on November 1st, 2023 to EJ Jacksteimer for the construction of a 3,100 square foot 3-bedroom home for Janet Holian, trustee of Holian Family Realty Trust. The subject property is located at 240 Windswept Way, Osterville, Mass. and 250 Windswept Way, Osterville, Mass. as shown on Assessors Map 051 as parcel 012-001 and 012-000 respectively. It is located in the Residence F1, RF1, and the Resource Protection Overlay District, RPOD. This appeal was filed with the town's clerk office and Planning Development Department Zoning Board of Appeals office on November 29th, 2023. The building permit is dated November 1st, 2023. Board shall make findings when either voting to uphold or overrule the building commissioner's issuance of this building permit. It's the board's responsibility to determine if the building commissioners properly issued the building permit and did not violate the zoning ordinance. I find that the board will affirm the building commissioner's issuance of BLDR 23-780 for the construction of a single-family dwelling at 240 Windswept Way, Osterville, does not violate zoning ordinance.
All right, so Mark has made a motion to affirm the building commissioner's issuance of building permit. Do we have a second?
I'll second that.
Sorry, second. Yep.
So Herb seconds. Roll call vote on upholding the building commissioner decision to issue the building permit. Herb Bodenseek.
I'm in favor of the building commissioner's issuance of the building permit.
Mark Hanson.
I'm in favor of upholding the builder's commissioner's issuance of building permit.
Aaron Webb.
I am also in favor of the building commissioner's issuance of the building permit.
And I am also in favor of upholding the building commissioner's decision to issue the building permit. I don't believe we have any conditions. So with these kind of findings, So we have upheld the building commissioner's determination. Thank you, Attorney Timon, Attorney Ford. I appreciate all the information to go into that. Moving along, appeal number 2024-020, New Cingular Wireless PCS LLC has applied for a special permit pursuant to section 240-108, antennas permitted by special permit in all zoning districts, and 240-125 zoning board of appeals. The applicant is proposing to extend the existing cell tower by 15 feet and co-locate its wireless facility at the site pursuant to the Federal Spectrum Act and the Town of Barnstable zoning ordinance. The subject property is located at 830 Wakeby Road, Marston's Mills, Mass, as shown on the assessor's map 013003. It's located in the Residence F RF zoning district. This was continued from June 26, 2024. Members assigned are myself, Herb Bodenseek, Paul Pinard, Aaron Webb, and Manny L. Again, Mark, you were not on this, and I believe you were present.
I was. Yeah, I'll say.
So if you're willing to, we can do that, correct, Anna? You can.
Correct. Yes, he was there.
He was present.
Yep.
Okay. Sorry, I'm still stuck on co-locate. It was supposed to say locate, I think. Attorney Parr, are you here?
No, actually, this is Michael Dolan from the law firm of Brown Rudnick. Mr. Parry couldn't be here tonight.
Yep. Go ahead.
Okay, thank you. At the last hearing, you may all recall that I
Sorry, can I interrupt for a second? Mr. Dolan, do you have another device there you're listening to? There's some feedback coming across from your it's gonna make concentrating very difficult. I apologize.
Yeah, sure. Let me
Like a female.
I don't see Mike Ford.
that's good. Are you sure it's me?
Anytime you talk, it's like a female.
Sure, but it's just echoing back and forth between anyway, try it again. Sorry.
Can you hear me?
Yep, that's better.
Is there feedback now?
No.
Okay, terrific. Sorry about that. So at the last hearing, you all may recall that I presented our application to the board for the approval of our proposed extension of the existing telecommunications tower and the co-location of AT&T's antennas and equipment. The board, as you'll recall, was reluctant to act on the application because it was not apparent that my client had completed the site plan review process. Specifically, the final letter signed by Brian Florence evidencing and summarizing the completion of the formal site plan review, which was dated March 25th, 2024, had apparently not yet been shared with the board. That letter confirming the completion of site plan review has now been provided to the board, and we are respectfully requesting that the board grant either a special permit or an eligible facilities request approval based on our application and the guidance of the Site Plan Review Committee.
Okay. Thank you, Mr. Dolan. Back to the board. Does anyone have any questions regarding this? So was the letter amended?
There was an initial letter that was, and I think Anna can speak to this too. There was a letter prepared after a preliminary meeting, and then there was a subsequent meeting of the Site Plan Review Committee, and their conclusions were in fact amended.
Okay, so you did go to formal site plan review. We just had the letter before only from informal site plan review.
That's correct. And you should now have the March 25th letter in which Brian Florence concludes that the appropriate relief is either a special permit or an eligible facilities request approval.
Okay. Do any board members have any questions?
Jake, if you said something, we were just offline we didn't hear. I didn't hear it anyway.
Did you hear we were just reviewing the site plan review letters, just getting a little clarification? Did you get that part?
No.
Okay, so at the last meeting, we only had the informal site plan review letter in the file that referenced that the project needed to go to formal site plan review. It actually had been the formal site plan review. We just didn't have the letter. So now we have the letter from the building commissioner referencing the approval of this.
Right.
So I think we have
I'm sorry. Which letter is it, Jake? I can't. On the Laserfish, it just has a bunch of listed New England Cingular Wireless. I don't want to click on them all.
If you make that wider, you'll be able to see the labels on each of the items in there. If you make the tab wider, but it says formal site plan review letter.
Okay. I don't know how to do that. It's okay.
Just up on the column thing. If you make the column for the labels wider, you'll be able to see better labels on them all. So I guess it just comes back to we still need to we need to go to public comment, and I'm gonna need your help with what we already read in, and if there's any new comments. But I guess we have two avenues of going for this. If I'm correct in this. Anyone else on the board have any more questions for the applicant before we open public comment? Okay. And were there not letters on this before?
There was a letter from Mr. Keys, who is in a butter, and I don't see it under public comment. It was there. It might be a Laserfish issue, but Chris Keys' letter was in support.
Okay. Is there anyone, I saw I opened public comment. Is there anyone here to speak to this? You just want to unmute yourself, say your name and address for the record. No one? 2 pages and no one? All right, so I'll make a motion to close public comment. Second.
Second.
Roll call vote on closing public comment. Herb Bodenseek.
I'm in favor.
Paul Bernard.
In favor.
Mark Hanson.
I'm in favor.
Aaron Webb.
In favor.
And I am also in favor. So public comments closed. Back to the board for deliberation, or if someone wants to make findings. So someone findings, or what's everyone's thoughts?
So it's either a special permit or the, sorry, I wasn't familiar with the other. You
could either, I think it's following our ordinance, but.
May I speak?
Yeah, go ahead.
Yeah, sure. The eligible facilities request is a federal provision under the Spectrum Act. And there are different mechanisms through that federal law by which an approval can be granted. But in this situation, we qualify for all of the requisite criteria where there's a mandate of approval. The special permit can be the actual vehicle. So we always ask for the EFR or eligible facilities request, and in this case, the special permit, but the issuance of a special permit would suffice.
Yeah. I think based on our special permit bylaw, I think we can grant it as a special permit, but other board members feel free to type in. Paul, your thoughts?
Go ahead. We've dragged this out long enough.
I think it can be. I think we can find a special permit. So, does someone else want to make findings, or is that on me? All right.
I'm sorry. I'm having trouble with my.
All right. Appeal no. I'll make a motion to close the public hearing. Need a second to close the public hearing.
Second.
Close the public hearing.
Motion to close public hearing.
Second.
Okay. All right. Roll call vote on closing the public hearing. Herb Bodenseek,
In favor.
Paul Pinard,
Second, Paul.
Mark Hanson,
In favor.
Aaron Webb,
In favor.
and I am also in favor. So that closes the public hearing. And so I will make findings in appeal number 2024-020. I'm going to make findings that the application falls within a category specifically accepted in the ordinance for grant of a special permit. Section 240-125 allows for a special permit. And after evaluation of all the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance. It would not represent a substantial detriment to the public good or the neighborhood affected. Site plan review found no necessary modifications or inconsistencies. And don't know why it says the single family nature of the property and the accessory nature of the detached structure are preserved. The site would remain in a similar condition as it is. The tower will just be slightly higher. I need a second for the findings.
Second.
Roll call vote in approval of the special permit. Herb Bodenseek,
In favor.
Paul Pinard,
In favor.
Mark Hanson,
In favor.
Aaron Webb,
In favor.
and I am also in favor. I'm going to make a motion to grant the special permit with the following conditions 1 through 4 on the staff report dated June 11th, 2024. Roll call vote on the conditions. Herb Bodenseek,
In favor.
Paul Pinard,
Paul?
Mark
favor.
Hanson,
I'm in favor.
Aaron Webb,
In favor.
and I am also in favor. So, Mr. Dolan, you are all set. Thank you very
Thank
much.
you very much for your time and consideration.
Been sorry to add delay to
Oh,
things. It was just the way it read.
No worries. Thank you very much. Bye-bye.
All right, so
Mr.
moving
Chair-
on to new bill number
Mr. Chairman?
2024. Yes,
Yeah,
Go
Mr.
ahead,
Chairman, I'm having very difficulty with my internet. I'm missing a lot of the words. Can I drop off? I think we still have, I think I'm the only one that's being affected here.
yeah, Aaron, are you all right?
Okay, yeah, I just wanted to see, Mr. Chairman, if we couldn't just jump ahead to McGill and let Attorney Boudreau, issue his continuance request, and then so he can go home.
Sure. Paul, you can drop off. That should be fine. How many of us are there? I'm going to have to recuse myself from 029. So as long as we have enough members to sit on that, I think we're okay.
I think we will.
All
We'll
right.
have 4. Yep.
So
Well,
I will go for
Mr.
appeal
Chair,
number. Yes, Anna.
Paul might be able to turn his camera off and still attend the meeting. Sometimes that helps with the internet.
Okay, let's try that. I'll hang on here.
Okay. We're good. Yeah, you can play with that while we just continue this item. Appeal number 2024-028, Scott and Melinda McGill have applied for a special permit pursuant to section 240-91H3 non-conforming lot. The applicant proposed to demolish the existing dwelling and construct a new single-family dwelling. The proposed dwelling will comply with all setbacks but exceeds the allowable by right lot coverage and floor area ratio. The existing lot coverage is 17.6% and the proposed lot coverage is 30.4%, where 20% is allowed. The existing floor area ratio is 21.4%, and the proposed floor area ratio is 45%, where 30% is allowed. The subject property is located at 394 Strawberry Hill Road, Centerville, Mass, as shown on Assessor's Map 248 as parcel 228. It's located in the Residence B RB zoning district. the applicant or the applicant's attorney, Boudreau, has requested to continue this item. Attorney Boudreau, quick rationale and a preferred date. I don't know if you would put a preferred date in your.
So subsequent to the initial filing, I also filed a petition for a variance, and that was done too late to have both hearings on this date. So I'm requesting a new date of August 14th. Respectfully.
Okay. And is that good? We have both items. We'll be able to have both items on the agenda that date?
Yes, that's just fine.
Okay. All right, I'll make a motion to continue appeal number 2024-028 to August 14th, 2024 at 7:01 p.m. Second. Roll call vote on the continuance. Herb Bodensee.
In favor.
Paul Pinard, if you can hear us.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
Larry Hurwitz.
In favor.
All right, so that item is continued with no members assigned.
Great.
Thank you, Attorney Boudreau.
Have a good evening.
Through that. Thank
Absolutely.
you.
Sure.
All right.
Good call, Aaron.
So back to appeal number 24-027, Poyant signs / Cape Cod 5 have applied for a variance pursuant to 240-65 signs in the B, UB, HB, HO, and SC1 districts. The petitioner seeks to install an additional wall sign for a total of 3 wall signs where 2 are allowed, and to install an oversized directional sign. Subject property is located at 1620 Falmouth Road, Centerville, Massachusetts, as shown on Assessor's Map 209 as parcel 013. It's located in the Residence C, RC, and the Highway Business HB zoning district. So sitting on this will be our regular members, Herb Bodensee, Paul Pinard, Mark Hanson, Aaron Webb, and myself. Attorney Cox here, or who do we have?
Good evening. It's Bethany Leonard, and I'm with Poyant Signs, representing Cape Cod 5 this evening.
Thank you. Whenever you're ready, go for it.
So we are requesting a variance to install 3 non-illuminated building signs. We are allowed 2 by code. The bank is currently doing a rebrand, so we are doing all of their locations with their new branding. So we are ultimately replacing all of their existing signs with the new branding. There are currently 3 signs on this building, so we do plan to take those down and then install new. The one that you have in front of you in the plan set is the one that's on the front elevation. This one is actually going to be moved down onto the building versus the up top going across, just because of the layout, and the square footage is actually going to be less than what's there now. Their existing sign is about 60 square feet, and the new one that we are proposing will be just under 12 square feet. And then in addition to that, we are requesting an oversized directional. Again, there is an existing directional there that we are proposing to replace with their updated directional. The current one is 2 posts with a panel on it. The new one does have a solid base, but it is only 3 inches deep. It's very thin, but it just goes solid to the ground. The square footage of the text area is basically equal to what is there now. So the square footage of the text is the same size as what we are replacing. And that is just to clarify which lanes, because as you turn, there are 2 lanes. And if you end up in the wrong one, you may not be able to get to the ATM, where the left lane is for drive-up banking only. That is basically all I have. I'm happy to answer any other questions that you guys have in regards to either sign.
Thank you. So this is a variance request. So again, we need to find some factors here related to soil conditions, shape, or topography of such land or structures. I have a hard time with that when the existing signs have been sufficient for the use of this property. But what's before us is to allow for 1 additional sign, and I guess for the directional sign to be oversized. So I guess we maybe have a leg to stand on here, but does anyone have any thoughts?
Mr. Chairman, is the directional sign the sign that's in question?
No, well, 2 signs are allowed, and there's 3
And they're
existing
smaller.
ones.
Yeah, so the third.
We're not to our square footage issue.
I mean, a lot of times our directional signs have been,
The directional is not counting the 3 signs.
right.
It's 2 signs on the building and
Oh,
1
2.
side on the ladder board, or whatever the
understand.
plaza board.
So to Mark's question, the issue is not the directional signs, is it? Or is the variance just for the third sign?
I think the variance is for the size of the directional sign.
So we were told that it's for both. So the directional is because of the size. So we need a variance due to the size of the directional. And for the building sign, they're only allowed 2 building signs, but we're requesting 3. So we're requesting a variance to have the 3rd building sign. So it's two items. So the quantity for the building sign and the square footage for the directional sign.
Can I ask a question? Is the second building, are the 2 ATM logos, are they considered 2 building signs?
No, those are direct. You've got the end of the table, end of the over the drive-through is 1 sign.
Yeah.
You've got a sign corner from the drive-through, and then you've got the sign that's.
Oh, the one on the top. Okay, I understand. Yep.
Plus, you have the ladder sign, but I guess we're not counting the ladder sign in the bylaw.
Could you orient for the one that says the Cape Cod 5-cent savings bank? Can you orient us? Is that facing another road?
So the reasoning for the 3 building signs is you can enter this plaza at a couple different entrances. So the main entrance that you're entering off the road does have a pylon sign. They are on the pylon sign. If you're entering from there, the sign you will see is the one that we are asking for the variance for here, which is next to their front door. So this is the sign you will see as you drive in. The other 2, one faces the plaza. So if you come in the secondary entrance to the plaza, you wouldn't see this sign because it faces the road and you're already in the plaza. So you'd be looking like directly at it if you're driving in from the secondary entrance that's furthest away from the bank. And then the other one is on the drive-through canopy, which faces the plaza directly. So if you parked and you're shopping as you're leaving, that is the sign you would see leaving the plaza to know that there is the bank there in case you need to use the ATM, or if it is your bank, you know it's there. Hopefully you already know it's there if it's your bank, but summer guests, if they're looking for an ATM, they can see that it is a bank coming in from any direction.
Right, but the Cape Cod 5-cent savings bank is really the back of the building, correct? And it leads to a smaller parking lot, is that correct?
That is the front. That is the main entrance. That is what faces the road.
Oh, it is. Okay.
Yes.
Yeah, the back expense is it's just sort of like going around the drive-through in the back.
Oh, right. Sorry, I was orienting myself on the drive-through. Sorry about that. Yeah, I understand. But does the drive-through?
I can share the other signs if you want me to share my screen. I can show you. We didn't include all of them. We only included the drawings, I believe, that we are requesting the variance for. But if you'd like to see the other angles, I can share it if you'd like.
We have all the directional signs and the clearance signs and the parking signs and everything in our.
Yeah.
Okay.
I'm just trying to determine if the drive-through sign points towards another building. I probably need an aerial. I need to look at it on an
That's
aerial.
Mark. It points out towards the parking lot. So the drive-through is sort of side by side with the what was a 7-Eleven initially, or maybe it is currently a 7-Eleven. I'm not quite sure,
Yeah.
but it faces out into the parking lot. The other sign above the ATM is. Again, hard to describe, but faces, I guess, in the same, almost sort of in the same direction in some way. And then the front sign faces Route 28. So there are 3 signs there currently, correct? You're just changing the signs.
Yes.
Yeah, I mean, yeah, it's a tough one because of the variance request, and yet they're pre-existing. They're just moving one longer one across the front of the building that faces Route 28 into a more modern, new branded sign, if I'm correct, basically, and nothing else really changes. So I don't know how to justify it necessarily. I'm not arguing that I have the answers to the variance requests, except they're all pre-existing. They're not adding anything at this point other than rebranding the signs, and in fact making them smaller.
Mr. Chairman, my understanding too is that in shape and topography, that can also include orientation. Because this is kitty corner in a way, the building actually has sort of a kitty corner entrance, like the actual lot that the building sits on has like it's not square. So you're seeing.
It is, I would agree with you 100%. It is a very oddly shaped building, given the configuration of the parking lot and the access to the drive-through. The way the building sits there is not squared to the rest of the configuration of the parking lot, for sure.
It's not squared to 28, that sign.
Correct.
The entrance is not squared to 28.
Yeah, and I misspoke. The ATM drive-through canopy faces directly towards the the plaza end unit, and the ATM one then faces out towards the parking lot. So I did misspeak. They face in different directions, but if we
the
can use that.
drive-through faces the convenience store directly. Like, so the drive-through one looks like faces the convenience store. The one near the ATM faces like the rest of the plaza. And then the one facing near the door faces the main road. And from the main road, you can't even like see that there's a drive up, depending which direction you're driving from. So the directional sign's important once you pull in for people to know, keep going around the building, there is a drive up.
Mr. Chairman, can we bring this back to the board now?
Yeah, it's questions on the applicant. We need to go to public comment and then we can bring it back to the board to deliberate. Do you have other questions, Paul?
No.
Okay. All right, so we'll open for public comment. Were there any members of the public who want to speak to this? All right, Anna, we didn't receive any correspondence, I hope believe, correct?
That's correct.
All right, so I'll make a motion to close public comment.
Second.
Roll call vote. Herb Odenseek.
I'm in favor.
Paul Bernard.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
And I'm also in favor. So public comments closed. It brings it back to the board for deliberation. I mean, this is one lot. It's very consistent with the lots in the zoning district. So I don't know how we're going to make variance findings on this, but if someone wants to take a stab at it, the whole plaza is one lot, one big lot. It's not a unique triangle shape in the corner or anything.
I do have a question. So the signage that's on the canopy currently, where it faces another building, is it, I'm not trying to take it away, but is it truly necessary where it faces another building? I mean, what is the distance between that canopy and the next building? 30 feet?
There appears to be a right of way sort of in between the two, almost like there's a driveway. Yeah, that would be my question to Cape Cod 5 and to Poyant really would be, how necessary is that canopy sign facing the convenience store, not visible from either the main access point of the plaza, the parking lot, nor visible from Route 28? I don't, and looking at the diagram and thinking about it in my head, I use that bank often, so I do, it is facing directly towards what would be 7-Eleven. It doesn't really get any visibility. Just thinking out loud, I'm not, Mark, I'm going to raise that same point. I do wonder how necessary it is. But I'm not,
Bethany, you want to respond?
So if you are in the plaza, I'm trying to think of what the other stores are over there. Like the cleaning store, or I think there's like a kid store, Dunkin'. Like, so if you're coming and you are coming around the building, leaving Dunkin', coming out, you do see it. You do have to be like basically at the convenience store to be able to see the sign coming from that angle. So you do see it driving. I drove around in a lot of circles in that parking lot looking at different angles. And then we felt also walking. Like, I'm not familiar with how much walking traffic there is around there, but if people were like walking through the stores and coming out, heading to the main road to get to a bus or anything like that, you do have good visibility coming from that direction. It's been there. We do think like it has to be useful. People have seen it. So we do feel it is visible. It's probably not the most important out of the three, but it is visible from if you're within the plaza and don't already know it's there.
Okay.
Mr. Chairman,
Again,
sorry.
Again, it goes back to like, you know, the intent of our council to make the sign code what the sign code is. You know,
Right.
yeah, it'd be nice to have a sign, but as was said, not 100% necessary. Like, again, I push our council to maybe update sign code here or look at it at some point, because it puts us in a hard spot. And even the directional sign, yeah, it's like, I get why it's oversized. It's not really oversized, but the way it's being calculated and measured, it's oversized because the whole thing's being calculated as a fin.
Right. So the directionals, technically, we count the area where the text is, so the white portion, and it is slightly smaller in square footage than if we calculate the sign that's there now, but it's still considered oversized.
So is the calculation the whole fin from the ground up is calculated as sign, or just the top triangle where the text is?
For the directional?
Yeah. Is it just the white part that's being calculated for sign size, or the white and the blue?
Just the white.
And that's oversized for directional.
Because it comes out to 7 square feet. And the current sign panel that's there is 2 feet by 3 foot 6 inches wide. So we're reducing the width and just making it slightly taller to make sure it's visible above a car. Like if there is a long line of cars, you can still see it as you're approaching.
Yeah.
Silly question. If you were to remove the words banking, would it change the sign size to bring it into conformance? Like if it just said left lane drive up, right lane ATM and drive up?
We can't, I honestly, I'm not sure what the actual square footage is within code. I have to double check that. We can look at it, but overall, like we do want to try to maintain the height, just to keep it high enough so it is visible from a distance.
Yeah, I mean, it would just be taking away, you could then bring the blue up a little bit if that's where it's being measured. Yeah. Our hands are just sort of tied here with this sign stuff. I've had conversations with counselors about it. Like, I think there needs to be a special permit option for this, because the variance is too tough for signs.
Yeah, because and ultimately, I mean, if we have to, but we are trying to keep their wording and how they call everything consistent with all of their locations. This is also the exact signs that we have in Hyannis at that location, at both their locations in Hyannis, to keep everything conformed to the same standard.
Does anyone have a direction that they feel they can go with this? We've closed public comment. We need to close the public hearing before we make full findings, but does someone have a way to go?
I would make a suggestion to the applicant that reducing the size of the directional sign and perhaps just removing the sign that's on the end of the drive-through would not be a detriment to use or to the ability for clients to find and or navigate, their way to to the bank, and that's just my thought. And then there's, at that point, there's no issue.
So Bethany, do you want us to vote on this, or do you want to withdraw it, or do you want to continue it and see what you can rework and then possibly come back if necessary? It doesn't seem like we're going to have an affirmative vote tonight.
So Andrea and Chris from Cape Cod 5 are both on this call as well. Could I defer to them to see if they're open to your suggestions?
Yeah, we've technically closed public comment, but yeah, you guys can discuss what you want to do for sure.
Mr. Chairman, Bert Tellerman here. How are you, Jake? Why don't we regroup and come back? I feel as though, obviously you're familiar with the site. We're down in a hole, kind of not the greatest visibility. I live right around the corner, so I know the spot very well. You take your life into your hands driving around that plaza sometimes. And so, kind of having good directional signage and visibility, especially given kind of the demographic around here, we're trying to be helpful. We're trying to, kind of update everything we have and make it better. If we can't get to a good spot tonight, let us regroup and come back.
Okay. Do you think you want, how much time do you want? We've got an August 14th or an August 28th hearing.
We can make it by the 14th, right?
Is Andrea or Chris allowed to just say they're okay with it? They're the bank. I just want to make sure they're okay with the 14th.
Yes.
And yes, and Bert is the bank.
We're all the bank.
Right. A motion to continue appeal number 2024-027 to August 4th, 2014 at 7:02 p.m.
Second.
Roll call vote. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Mark Hanson.
I'm in favor.
Aaron Webb. And I'm also in favor. Thank you guys for standing. Yeah, lean on the variance conditions for us. If you guys feel past, you can convince us that it follows. We can lean on that.
Okay. Thank you.
Thank you. All right. So the last item of the night is
Woodwell.
Yeah. And I will read into the record and then I'm going to recuse myself. In appeal number 2024-029, Richard and Linda Woodwell have applied for a special permit pursuant to section 240-91H to develop lot protection. The applicants propose to partially demolish, reconstruct, and expand the main house and relocate the tower dwelling and place it on a new foundation. The existing gross floor area is 2,428 square feet, 22.5%, and the proposed gross floor area is 3,205 square feet, 29.7%, where 30% is allowed. The subject property is located at 9 Lafayette Avenue, Hyannis, Massachusetts, as shown on the census map 287 as parcel 043. It's located in the residence F1, RF1 zoning district. So sitting on this, and I'm going to hand the chair over to Herb Bodenseek, Paul Pinard, Mark Hanson, Aaron Webb, and Larry Hurwitz. Herb, it's all you.
All right. Thank you. Good night. Unless you want to hang around. Okay. Attorney Ford, do you have a presentation?
Yes, I do. And given the hour, I'll try and be very straightforward on this one. I believe Gordon Clark is also on, who has designed the alterations and the expansion that's proposed for this project. As read by the chair, it is over in Hyannis, 9 Lafayette Avenue. I should tell the board that it is in the National Register Historic District. We have applied, and there is a hearing, there's a hearing in August to see whether the Historic Commission will approve this. Generally, we would try to go to the historic first, but scheduling was such that we couldn't get an historic slot in time, and so we brought this before you. Why? Because on the National Register Historic District inventory, the building is listed as non-contributing. And so Gordon's initial comments with staff are that this is probably not something that is of great concern. The tower is, but the house itself it apparently is not. So we're comfortable, if you're comfortable, in going forward with the zoning hearing at this point, not having gone before the historic district, for which we need approval.
That should be fine.
All right. So that said, we're on a lot that's about 1/4 acre. We want to do what's not a full demolition, but a partial demolition. But we've talked to the building commissioner, and he believes that we're demolishing enough that we're not simply an alteration, and we need to go under the raise and replace bylaw and meet the metrics under that. So what section under the raise and replace are we in? We can't do it as a matter of right. Why? Because our setbacks don't meet the current setbacks. So we can't go through it in an as of right raise and replace. We can, however, apply for a special permit under section 3 of 240-91H. That allows you to grant a special permit if we meet certain metrics in the proposals. And in the first instance, rather than meet the existing setbacks, we're holding the setbacks in the front. We're complying with the setback in the rear on the alteration. And the tower, which is only less than a foot off, we're able to move it a bit. So it's like 2.1 feet off that line. So I think we meet the first requirement of metrics under H3. I'm getting some kind of feedback here. Can you hear me?
I can.
Okay.
I can.
All right. I'll keep
Does
going.
anybody have their microphone on, Aaron? I see yours is on.
Okay, I'll keep going, Mr. Chairman. So we meet the setback requirement under H3 because we're either staying the same or we're getting a little better. The little better is the tower and the rear setback. We'll meet the rear setback of 15 feet on the house, and the tower gets a couple of feet off the lot line where it's only inches off the lot line now. With respect to the tower, we're gonna have a new foundation under that, but that doesn't have any alterations to it. We're just gonna put new shingles on it and new windows, but it'll all be the way it is now. It has 2 bedrooms in it. The 3-bedroom house, if you've seen his design, what we're proposing to do, let's see, the existing lot coverage on the main house is 1,741 square feet. That's 16.1%. We end up with a proposed lot coverage with the reconfigurations and the addition of 2,044 square feet. So it's 18.9%. Therefore, we meet the requirement of H3B because we've got to be 20% or less. The existing floor area is 2,428. That includes the tower, 22.5%. And the proposed floor area is 3,205 square feet. So we're at 29.7. We stay under 30. So we meet the metrics under H3B, the floor area ratio. And then as far as building height goes, we're far less than 30 feet. And the bylaw is 30 feet or 2.5 stories. And therefore, we believe we meet the metrics for H3C for building height. Finally, you have to make an overall finding, and here's where your discretion is, that this project, even if we meet all those metrics on a raise and replace, will not be substantially more detrimental to the neighborhood. Gordon has tried to do a design that we think historic is going to like. As we say, the house, I know it's listed as the 30s, but historic has it listed as the 50s. It's a block foundation underneath. There is some sheathing. Gordon thinks it's somewhere in the 40s or 50s, but it's not a real historic house as opposed to the tower, which has some real history to it. And that we'll end up saving and just put it on a new foundation and give it a new skin. So I don't believe there's any neighborhood interest in this. The one correction I will give you, I erred in the application. I applied on behalf of Richard and Linda Woodwell. Richard is deceased, so it's just Linda that's on the application now. She's the owner of the property. Happy to take questions, and Gordon is as well.
Anyone?
I don't have any.
Oh, I didn't assign members. Okay, so.
Chairman Dewey did, Herb.
Oh, that's right, he did. He did everything. Okay. Does anybody have any questions? I think it's a straightforward project with the right intentions in mind, especially the tower.
Yeah, I think, from my view, it will save the tower, although it hasn't brought up that it would falling down, but with a new foundation that'd be insured. And I think it's as I read the plans, it's drawing the tower back into the lot, so it increases marginally the setbacks.
Very good. Anyone else?
Nope. Public comment?
Attorney Ford, do you have anything else to add, or should we go to public comment if there isn't any?
Public comment would be fine. I have nothing further to add at this point.
Do we have any public comment?
We do not, Mr. Chair.
Very good. I
think you have to open it.
Close public comment?
Did we open it?
I didn't open public comment. Okay, so open public comment.
Mr. Chair, you might want to ask if there's anybody online.
Oh, I thought that's what I was asking, but.
Oh, there's no written public comment.
Oh, okay. All right. Anyone online like to comment? I may be turning red. Okay. I would move to close public comment.
Second.
All in favor? Well, roll call vote. Aaron?
I'm in favor of that, Herb.
Mark?
I'm in favor.
Paul?
In favor.
Okay.
And Larry?
Oh, Larry.
Larry's in favor.
I'm in favor.
Hi, Larry. Okay.
Here.
Back to the board. Does anyone have any concerns?
No, I'll go for it though if you want me to just.
Okay.
Hanging out, Mark. Hanging out.
I will close the public hearing then.
All right.
Do I hear a motion to close?
I will, hold on, we got to do the close the public hearing. So I second Herb's.
Oh, I'm sorry. I thought we
motion.
did that.
No, we closed public comment. Now we're closing the
Oh,
public
public hearing. Yes, I'm sorry. Go
Somebody
ahead.
added this thing in just, okay. So.
So moved, Herb.
Public hearing.
Yeah, I second. Let's go.
Okay. Roll call vote. Larry?
In
You in
favor.
favor?
In favor.
Okay, Aaron?
I'm in favor.
Mark?
I'm in favor.
And Paul?
In favor.
Okay. Would someone like to make findings?
Yes, please. I'll go.
Okay, Mark, thank you.
With regard to special permit number 2024-029 Woodwell, section 240-91H, 3, develop lot protection, demolition, and rebuilding on non-conforming lots. Richard and Linda Woodwell have applied for a special permit pursuant to section 240-91H, develop lot protection. The applicants propose to partially demolish, reconstruct and expand the main house and to relocate the tower dwelling and place a new foundation. The existing gross floor area is 2,428 square feet, 22.5%, and the proposed gross floor area is 3,205 square feet, 29%, where 30 is allowed. Subject property is located at 9 Lafayette Ave, Hyannis, Mass, as shown on Assessor's Map 287, as parcel 043 is located in the Residence F1 RF1 zoning district. I find that the application falls within a category specifically accepted in the ordinance of a grant for a special permit. Section 240-91H3 allows for the demolition and rebuilding of a residence in a non-conforming lot. Find that site plan review is not required for single-family residential dwellings. Find after an evaluation of all the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. Further, section 240-91H3 requires the board to find that if the proposed demolition and rebuild cannot satisfy the criteria established in H1 as of right, then the board may allow the demolition and rebuilding by special permit, provided that the board finds that the proposed yard setbacks must be equal or greater to than the yard setbacks of the existing building. We have found that the proposed front yard setback and side yard setbacks will remain. Rear yard setback will conform to the required 15 feet, and also the tower will be moved slightly in order to bring it back further into the lot. The proposed lot coverage shall not exceed 20% or the existing lot coverage, whichever is greater. The existing lot coverage is 16.1% and the proposed lot coverage is 18.9%, which it does not exceed the threshold. That the floor area ratio shall not exceed 0.30 or 30%. The existing floor area ratio of the structure being demolished, whichever is greater. The existing FAR is 22.5% and the proposed FAR is 29.7%, which does not exceed the threshold. The building height in feet shall not exceed 30 feet to the highest plate and shall contain no more than 2.5 stories. Find that the proposed height for the principal dwelling is 17.5 feet and the proposed height for the tower is 20.5 feet, falling into compliance. We're also asked to find that the proposed new dwelling would not be substantially more detrimental to the neighborhood than the existing dwelling. Based on the plans submitted, it appears to be in conformance with like-type properties in the area and is making an attempt to maintain part of the property. Those are my findings.
Do I hear a second?
Second.
Right. Those in favor, Larry?
In favor.
Aaron?
In favor.
Paul?
In favor.
Mark?
I'm in favor.
And I am in favor. Go ahead, Mark.
Yes, and with regard to staff report dated July 12th, 2024, I have suggested conditions number 1 through 6. Attorney Ford, are those acceptable to you and your client?
Yes, they are.
Those are my conditions.
I second the final.
Oh, Paul seconds the conditions.
Okay, all in favor? Paul?
Yep, in favor.
Mark?
I'm in favor.
Aaron?
I'm in favor.
Larry?
In favor.
And I'm in favor. And please pass along our condolences to your client for their loss.
Thank you very much, Mr. Chairman and members of the board. Good night.
Thank you. Okay.
Make a motion to adjourn.
Second.
Wait a minute. We have correspondence. None. Okay. Matters not reasonably anticipated by the chair. None. Upcoming hearings. Not none this time. August 14th, 2024, August 28th, 2024, and September 11th, 2024. Now, did you have something to say, Aaron?
I'm ready to go. I'm trying to talk as fast as Mark did. Appreciate that, Mark. You're a speed talker.
I second.
All seconds. All in favor.
Aye.
Aye.
Roll call vote necessary. By order of the acting chair.
Good night, everybody.